On today's episode, we're going to talk about the very exciting topic of employee contracts. So don't tune out yet. It's actually might be more interesting than you think. We're going to talk about what are the sorts of things you do want to have contractual agreements with your employees, and where might those types of agreements live, separate agreements within your employee handbooks, et cetera, et cetera.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Why did I want to talk about this issue of what is contractual and what is not?
Right.
I don't know why. We talk about these themes, right? Certain things keep coming up in the last few weeks. And I know you've had some calls on this too.
Say, you mentioned it and I had just gotten off the phone with the client.
We can't explain it.
Yes.
But literally when I was thinking about this episode and what I wanted to talk about with you today, I was working on several issues related to this. I said, well, I'm doing the client work on this. This is what we're going to talk about.
Let's talk about it then. Yeah.
And there seems to be not necessarily confusion. I don't want to say that, but differences of opinions, strategy, etc., that might not be fully thought out by many organizations. When it comes to, for instance, what do we say in an offer letter?
Yeah.
Do we have something called employee agreement? And if so, what do we say in there?
Right.
Do our handbooks say nothing in this is a contract? But then we put things in that we really want to be a contract.
And we see this all the time.
Right? We see this all the time. In a general... again, I don't want to say confusion because that sounds like a negative, but maybe not thinking it through carefully about what do we want to be a contract with employees? What do we not want to be a contract with employees?
Yeah.
And how do we make sure those two things live in separate places?
That's right.
Right, so there's no confusion.
Mm-hmm. And to be clear, when we're talking about this, we're talking about our at-will employees. So these are not employees with a bargaining agreement, for example. They're not
absolutely.
Union employees. And from time to time, we might see a high-level executive who actually has a contract for employment.
Yes.
That's not what we're talking about
Meaning
here.
we will employ you for a certain amount of time, and this is how we will employ you. Right.
Exactly.
We're talking about
your classic at-will employee with whom there are certain enforceable agreements that you might want in place. In other words, things that they promise you or say they will do or won't do. Yeah. And if they don't comply, you might want to go to a court and say, we had a contract.
Yes.
Right? Judge, I have a claim against them now because they violated the contract.
That is an awesome description of what a contract actually is.
Yes.
And not that this is therapy, but I will share with you, way back in law school, my first class, my first day of law school was contracts.
Right.
I had not come from a business background, and I struggled with that class. If the professor had just said that at the beginning to frame what we're talking about when we say contract, when I say the word contract, what am I talking about?
Right.
That would have made my whole first year of law school a lot better. I'll also add, so we did talk about like what is, when we say contract, we know what we mean, right? It means you can enforce it. It's a promise.
Exactly.
That you can then go complain to a judge about. If someone breaks it, it also means you have the potential for damages.
Right, if they don't do it.
So not just forcing someone to do what they promised to do or not do, but if they don't do it, and that causes your business damages because they didn't do it, I can get money for that, right?
That's right.
And so those are the two important things. So a contract are just promises or statements that are enforceable. That's what makes the difference between a contract and not a contract.
And to have that, really, you just have to have a mutual agreement, an offer acceptance.
Yep.
And if somebody's promised to do something or not do something, they must have gotten some small thing in return for it.
Right.
And employment can be the some small thing they get.
Even one additional day of employment for an at-will employee.
Yeah.
Right. Just continued employment.
Could be. Okay.
Right. Okay. So now that
that's the framework. This all sounds great.
Right.
So let's talk about why is it important to be mindful about how we frame these agreements or contracts and be thinking about what to include and what not to include?
So I think the traditional view has been one of mostly defense from the employer side. We don't want anything to be a contract because we don't want an employee
To be on the hook.
to be able to say to us, you promised me this and you didn't do it.
Right.
And now I can hire a lawyer and take you to court.
And take you to court. For example, can I just give an example that I see a lot?
I suppose.
Right? So I shouldn't say a lot, but if we have a statement, for example, in a document that appears to be a contract, and that says, we will give you a performance review every year.
A lot. I see that a lot.
Okay? I see this a lot. And as part of that, we will decide whether or not you get a pay increase, right? If an employer, without really thinking about it, throws that into a document that is a contract, it's a two-way street, those contracts. That's the thing.
Yep.
And so what that means then, if we don't do the performance review, if we don't live up to our end of the promise, then that employee can sue the employer for a breach of contract.
Yes.
So it's important to be thoughtful.
It's thoughtful.
About how we do this.
We normally do a takeaway at the end of the episode, so spoiler alert.
Right.
But the takeaway here is to be thoughtful about it. There's not a lot of rights and wrongs, frankly. It can depend on, you're just going to we want you to be thoughtful with your business leaders about what you want to be contractual and what you don't, right? So when things go sideways with an employee, you're not surprised or disappointed.
What you've promised them and what may be enforceable.
And what maybe they've promised you. But what I have found and why I wanted to talk to everyone today about this is, in my experience, employers have traditionally really shied away from the contractual, making anything contractual. Again, the handbook is a complete set of everything, and then we say this is not a contract, including, by the way, a confidentiality policy.
Yeah, but not
right,
if
and other
not
things.
if Miller Johnson has reviewed it.
But so that's why I really want to say, I want everyone to understand there are things you may want to be contractual. And because we're on the employer side of things, we want you to think about what promises that employees can make that you want to be a contract with
For
your
which
employees.
you might, again, and when you're thinking about what those might be thinking about it through the lens of, would I want to go to a judge and say, Judge, Rebecca promised she would do this and she didn't.
Yes.
And now it's harmed my business, so please do something about it.
Yeah.
Right?
Yep,
okay.
absolutely.
So what kinds of things can you think of that employers typically want to be contractual?
So let's hit the easy ones first.
The easy
right?
one is confidentiality.
Because I already said
Non-compete, confidentiality.
confidentiality of your information, any sort of what I'm going to take to call now restrictive covenants, because the status of non-competes we're not sure about, but it could include not just a non-compete, but a non-solicitation, right? A non-poaching.
Yeah, of course. All of the
things
under the umbrella.
along those lines. So we're going to talk about, after we talk about the different types of things you might want to have contracts about, then we're going to talk about where those agreements should live.
Okay,
so don't worry if people are, because I guarantee you people right now are talking to their screens or to their podcasts and saying, should I have a separate agreement on that? We'll get to that. Okay, because there are options.
Okay, so that's the top of the list.
Those
that's
are the
most
tops
common
of the
thing
list,
I see too.
Right, that no one needed to tune in to hear, right? Other things that employers should be thoughtful about and think about. One is computer system access and use, right? Because employees can do a lot of damage to your computer systems, right? And you may want to recover for some damages if they do those things, right? And those policies can be full pages. I mean, they can be pretty intricate. Another one can be intellectual property, right? And by that, I mean writings, inventions, more often writings, right? We may want to have employees assign ownership of those things to the employer if they were getting paid by the employer while they were, right, inventing or writing, right, a work for hire, concept, right? That is the sort of thing you actually do need to have a contract for in writing to make any headway there after the employee leaves. What else comes to your mind?
In some states, you can get a shortened limitations period, meaning employees can contractually agree that they have a shorter period of time to sue the employer after they disagree with some sort of employment decision that was made against them. But that would have to be a contractual agreement in order to be enforceable by a court. Other things that I commonly see are, you mentioned electronic communications. I would also include on that ownership of cell phones, laptops, etc., making clear, having a contract in place about who owns those.
Good point.
So that if an employee takes a cell phone that the employee alleges they now own because they were allowed to use it as part of their employment, again, there's a document you can bring to a judge and say, Judge, please order that employee to return to us that device.
Love it.
Promises or contracts to repay loans, bonuses, educational expenses, cost of uniforms, et cetera, et cetera, et cetera. We get a lot of phone calls about this employee, we gave this employee X, and they didn't return it, or we gave them a bonus and they were supposed to repay it. And can we sue them for it? And our response is, well, where's the contract, right? Remember?
Where's
if you
the
want us to go to a judge,
promise?
Exactly.
You know they made a promise, but where's the enforceable
That's right.
promise?
So those are things. What about you? Do you have any more you can think of?
I do, but picking back on that for a moment, where I see that as like repayment of relocation expenses, or a starting bonus if someone leaves within a certain amount of time. That absolutely should be a contract, right? A written contract. Again, not this isn't going to be right for every employer, but something to consider and be thoughtful about is if we want employees to sign promises that they will not violate any restrictive covenants they have with a previous employer, and that they will not use or disclose a previous employer's confidential information. Right? That can be very helpful. If one of those things unfortunately does occur and the former employer wants to come after you, the business, you can then maybe make it the employee's problem, right? Instead of your problem, right? You can let them go and then it becomes their problem and you are not, potentially, you have a good argument, right? That you are not on the hook for that employee violating their agreement with you and with the former employer.
Where you and I see employers maybe tripping up a bit is including some of what we've just talked about in things, documents, that they don't really want to be a contract, or they even say is not a contract. So the classic example is a handbook with a confidentiality clause, and you mentioned that. And I would say more than half of the handbooks that I receive from clients have a confidentiality clause, which is fine. It just means that's a policy. And if the employee violates it, then it could result in corrective action or maybe them losing their job. But it doesn't mean you can go to a judge and get damages because it's not in a contract.
So we both see a muddling in the same document. Of
things that are contractual and not.
And, what happens is the whole thing becomes contractual, in my opinion. We may have some difference of opinion on that, but there's at least an argument to be made that everything then, including, for instance, a statement of salary, performance evaluations, that other things that you really don't want to be contractual become contractual because part of it are things you want to be contractual, so you have the employee countersign and it looks like a contract, et cetera, et cetera. So that's exactly why the message here, the big messages are to be thoughtful about what you want to be a contract and keep separate the things you want to be a contract and the things you do not want to be a contract, or at least have them in separate parts of the same document. Right. So in handbooks, sometimes we have different sections of handbooks. So there's nowhere to wrong. There's lots of ways you can accomplish that. One way is in a handbook. If you want everything in one place, you can say this part of the handbook is not contractual. Boom, 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 and then in big letters so they will see it. This part is contractual, right? And sign off on it, and then the acknowledgement form also sign off that those sections are contractual. So that is one potential strategy to attack it. Another could be actually having separate contracts, separate documents, right, for each one of these things. Or maybe you have a handbook that's not contractual at all, but then you have employee agreements that contain all of the contractual provisions, right, that look and feel like a contract. Right? Just make sure when you do this is the mistake we see. There are often other things included in those employee agreements that you really don't want to be contractual. But everyone throws in the kitchen sink. Right? About everything the employee can expect when employed with you.
That's exactly
That's not an employee contract.
You do not want that to be a contract. Again, I know we've said this before, but I'm going to say it again. When you call something a contract, okay, it's a two-way street. That means that all the things that the employee is promising they do or not or won't do, right, is legally enforceable. But also all the things that you're telling them they will receive also is legally enforceable. And if that changes or stops, then they can go to a judge and sue you for it. So the performance review was the easy example we gave, right?
Well, because we see it all the time.
As we see it all the time. Because we see it all the time, right? Yep. You wouldn't want to have an employee contract that says we will always have you be a full-time employee, for example, right? Because maybe their job might change and you want to change that to a part-time position and you wouldn't want them to be able to go to court. You wouldn't want to call an entire handbook, in my opinion, a contract unless that employer is willing to stand behind every single thing in that handbook, right?
Right, and every time there's a change,
promise to do their performance evaluation.
Have it re-signed anytime there's any
change. Exactly. So
let's talk about offer letters then. Okay, so we've talked about the employee agreement that looks like a contract with numbered paragraph. We talked about the handbook. We see a lot of offer letters, right? They're very common. Some are very short and simple, and some include a lot of the things we just talked about.
Sure.
I think that falls under the same category as the employee agreement, right? Think about carefully what
you
want to be.
A lot of muddling.
A lot of muddling. What do you want to be a contract and what do you not want to be a contract? And here's a practical solution to that. In the offer letter, say, this is an offer for at-will employment, right? And then we anticipate your, salary to be, your job duties. You'll be reporting to so-and-so.
Which may change from time to time.
You will, and your first day will be this. During your onboarding process, you will be required to sign, right?
Sure.
And agree to, right, various contract, and you can list them so people know, especially if there's going to be a restrictive covenant. I think that's only fair. And sign on to our employment policies and our employee handbook when you'll be given a copy of it, et cetera, et cetera. So that's how you can accomplish what you want to accomplish without muddling it all.
That's exactly right. I'll just give one quick example because I've seen this multiple times.
Okay.
An offer letter that says, nicely, this is at will, we can end this relationship at any time. This and I've even seen them to say this offer letter is not a contract, right?
Sure, yeah.
But then includes the clause that says we're giving you a signing bonus and you agree that you will stay on for at least a year, right? And if you don't, then you will pay it back.
Right.
Sign the offer letter at the bottom.
Which is not a contract.
Which we've said is not a contract, right? And then the client sends it to me and says, we want to enforce this and we'd like to get this money back from the employee. And I have to give them the bad news of, this is unenforceable because I know you put it in there, I know they signed it, but you've said it wasn't a contract. So another way to do it would be to say in the offer letter, we're giving you a signing bonus contingent upon you signing even the enclosed very short signing bonus agreement.
Yep, love it.
And enclose that, and then they sign and return the signing bonus agreement. Now, see, you've separated those two and they're not muddled together.
Yes. Okay, so the takeaways, anything else you want to add?
No, I just got excited about that example. This topic really is much more fun.
It was more exciting than you thought it was going to be. Can you give me that? It's almost more of a gripe session.
We have so many ideas.
Like. Yes. More of a gripe session because clients are frustrated when we give them an answer they don't like, but we are equally frustrated because we do not want to be a department of no, right? We want to help the clients, right, collect the bonus in your example. Right. So we just want it to be set up properly on the front end, right? So we can be as helpful as possible when issues arise. Okay, so the key takeaways from today's episode, if nothing else, it's be thoughtful about what you want to be a contract, what promises you want to make to employees that you want to be enforceable, what promises you want employees to make to you that you want to be enforceable, and make sure your contractual agreements and your non-contractual statements are separate.
Right. So when Rebecca says, send me the thing that I'm going to show the judge, right? You can pull it up and say, here you go.
Yes.
Right.
Those are the key things to think about. This is really more of a food for thought type of episode than anything else. But thank you so much for indulging me.
Yeah,
it was fun.
Rebecca. Always.